to Boston after experiencing hurricanes or earthquakes in their home countries. But we also have a lot of immigration from folk experiencing things like crop failure or drought or flooding, who don't think of themselves as, but certainly are, climate refugees. And as this population transforms Boston, making it into one of the cities with the largest foreign-born population in the country, we have to think about what those folks have experienced and how to integrate them into the climate justice movement, how to ensure that we see immigrants really reflected in what we think of as environmental resilience and climate justice. We also have to think about the actual physical impacts on Boston itself. Boston is a coastal city that is certainly in danger of being flooded or of being drowned as sea levels rise and as temperatures rise. I heard recently that in the next 30 to 40 years, Massachusetts will have a climate similar to that of North Carolina. And the impact of that on farming, on sea level rise, on flooding is astronomical, especially for people of color and immigrants and low-income folks who will be the first and hardest hit by climate change. I'll give you an example. East Boston is a historic gateway to the city of Boston where immigrants and newcomers to the city or to the country have dwelled. It is currently home to a very large Latinx population. But this population is at increased risk of flooding related to climate change. The subway lines flood whenever there's heavy rain. There's an increased need to protect and insulate the marshes where a lot of stormwater and seawater go. And without these resiliency measures, there's a very good chance that East Boston will experience considerable harm and damage from the effects of climate change. And so we need to start thinking about that now and thinking about how we can ensure that we don't just forget about those low-income immigrant people of color living in East Boston and focus just on places that bring Massachusetts tourism, like Cape Cod, for example.
But what is the role of a lawyer in impact litigation ex ante, from before the harm is done? Often we think of the role of the lawyer as entering the picture after the fact to vindicate a right or to obtain a remedy for a harm. And it's difficult to get the law to respond at an earlier stage.
I think that for us, we're looking at what is already happening and what has already been considered, proposed, planned, et cetera, in terms of remedying climate change. So, for example, when Massachusetts receives grant money from the EPA, we want to make sure that that grant money is being spent equitably, that we aren't, again, just focusing on projects in Cape Cod, but are also making sure that money goes to disaster relief in places like East Boston or Fall River. We can look at steps that Boston is taking to promote transit. So Boston and Massachusetts are revitalizing the MBTA, which is our public transportation system out here, and contemplating a move to going fully cashless, which does sound great until you remember a large percentage of folks who are immigrants, who are low income, who are elderly, don't have credit cards or don't have bank accounts, or may not have smartphones to be able to access that on their cell phone. So we want to make sure that these folks aren't then totally without transportation. We also look at resiliency measures. So as there's increased development in East Boston, and as the Boston Planning and Development Agency gives the green light to developers, making sure that agency holds those developers accountable for resiliency measures, making sure they commit to certain climate measures or to remedying other actions that they will take in the course of development that could cause damage to our general resiliency.
I can see what you mean when you refer to your work as a type of general counsel function, because when you press on one issue, it raises others. And when I think of immigration into the state and fostering resiliency, getting people counted in the 2020 census immediately comes to mind.
Absolutely. And it's actually funny you mentioned that, because I was just at a conference on Friday where we had a presentation from a woman who was describing the connection between a lack of communication infrastructure and its relationship to disasters. So places where there's weak broadband or poor cell phone signals, and it's harder to actually not only get information to folks about when massive storms are coming, but also to help them evacuate and deal with the aftermath of the storm. And she connected that specifically to the census, because the census next year will be going online, the first census to do so. We are concerned that means that folks with poor communication infrastructure, those without broadband, those without access to smartphones, will be unlikely to complete the census, when those are precisely the individuals who are hardest to count in the first place. And so I think one thing I'm learning over the course of this project is that climate justice means so many different things. It doesn't just mean, do you have LED lights in your building? And are you trying to reduce plastic? It also means transit justice. It also means communication justice, right? It also means investment in infrastructure. And how is that being divided over an entire state? I think being able to think about climate justice as holistically as possible gives us the best shot that we have of ensuring that these problems are addressed.
As we wind up, I have a hypothetical for you that I think you're uniquely placed to answer. We currently operate under an equal protection regime, but it has always struck me that a commitment to equal rights would be different, that it would look different because the burden of getting justice would look different under an equal rights regime. So now, when you pursue a claim, the wrong needs to look a certain way and you need to incur costs personally to get a remedy. Do you think that there's a meaningful distinction here? Would civil rights look different under equal rights rather than our current equal protection paradigm?
Absolutely. And I think we often hear from clients directly that what the present civil rights regime is insufficient for their needs. And I can think of a very specific example for this.
Please do.
We had been working with these community groups over the redevelopment of a historic building in Boston. And when I say historic, I mean it was not officially historic in the sense that it had a place on the historical register. Had been redeveloped, but the building was sort of emblematic of a previous building that had served as a way stop as part of the Underground Railroad. It had an emotional resonance as it had been a place where, in particular, African-American women would come stay during the Great Migration. And so it had sort of an emotional importance to the community. And when the building was sold to developers to be changed into condominiums, there was a real sense from the community groups we were working with that there had to be something we could do. And often our response would range from, well, they haven't officially got all the permits yet, so it would be too early, it'd be too premature to file any kind of legal action because it may still not happen, to also saying, well, just because we all feel this sort of shared ownership of this building doesn't mean we actually have private ownership, and we can't just take someone else's private property away from them, and essentially trying to manage expectations around what the law actually could do. And there was a real frustration from these community groups as to why exactly the civil rights regime couldn't step in when there seemed like a very clear wrong being done to the community. Why did they need to find a particular individual who'd be able to vindicate this? Why did they have to wait until this particular time period? All the sort of concerns that come across with standing that bedevil lawyers and I think are really frustrating to just individual people. That's certainly why a very important aspect of legal work is also thinking about how to make the law as flexible as possible and as responsive as possible to our present needs. We are part of a coalition that is supportive of a new bill that would allow for disparate impact lawsuits to be brought in Massachusetts for a variety of different protected categories, because we're afraid that the federal government is restricting your ability to bring those kinds of lawsuits. And so I think that's an example of how we can still create new laws that are responsive to our particular needs. In this case, the fact that discrimination is hard to demonstrate as intentional in 2019, but it's easier to demonstrate as disparate impact. So it's having an impact on people of color or on immigrants or on women or on the disabled, even if you can't point to language in the statute that says we intend to disadvantage this particular group. But I will also say that I've been so impressed over the past few years, especially at the creativity that legal advocates have demonstrated in bringing these kinds of cases. I'm thinking, for example, about the public charge litigation that was brought in New York and Washington State and California, in which states made the argument that they would be injured if this regulation, which alters the conditions by which someone can get a green card, because that meant that their treasuries would be depleted if people were disenrolling from benefits because they were afraid they couldn't get green cards and therefore relying more heavily on state agencies. That's a very creative argument, I think, and one that got around a lot of standing questions because the states could say this is already happening. We don't have to wait for someone to be denied a green card to show that the harm is real.
But in order to make that kind of argument, you actually have to have a significant engagement with the empirics to dig into the data, right?
You do. And I think the one thing that's really important about that case is that given the requirements just on a complaint, that the state was able to demonstrate a couple things. One, they had a lot of declarations from individual providers saying, anecdotally, we can see that fewer people are coming into our clinics, that people are disenrolling from these benefits, that people are telling us they're afraid. And that is, especially for the purposes of a complaint, that's really strong. And then you also had a number of scholars who had said over the year and a half in which this rule was being debated, we project that, we might see disenrollment rates of up to 30%. We project that, the impact on state treasuries will be X, Y, and Z. And those, I think, were very, very important. And in fact, a lot of these complaints were pulled together and filed within a few days of the final rule being published. And you can, of course, through the course of discovery over the life cycle of a case, generate, produce, and acquire additional information. But just at the point of filing the complaint, those were two very important hooks for the states to hang their hats on.
I think it's clear from what you've told us that there's a lot of creativity, a lot of rigor, a lot of flexibility, and a lot of just raw effort that goes into impact litigation. Do you have any final words for our listeners?
I think the final words I would say is that we are able to do this work not in isolation, but building off of and in conjunction with the work of so many advocates, so many volunteers, so many activists. It all kind of goes together. So there's, on the one hand, there's groups like us filing cases in court, but there's also those activists who flooded the airports when the Muslim ban was announced and who created an enormous amount of pressure and who protected those people who are vulnerable. I think we are part of a much larger network of folks trying to protect the Constitution and protect our most vulnerable community members. And I salute every person involved in that effort. And thank you for listening to what we have to say.
Lauren, thanks so much for being with us today. We've learned so much about the work that you do and the impact that Lawyers for Civil Rights has. It's really been a pleasure.
Thank you very much for having me. I really, really appreciate it. I wish you all the best, and let me know if you ever like me to be back on.
Thank you.
And that's a wrap on another episode of UC3P. Credits to Arjun Motta for co-producing and engineering, Irene SanPietro for co-producing and interviewing, and me, David Raban, for editing. Our assistant production managers are Arjun Motta, Olu Ogidan, Saumya Karun, and Suo Wu. Our communications director is Thomas Krasnation. Our finance director is Donovan Harvey. Our publisher is Haz Yano. Our intro music is Knockout 2 by The 2B. And our outro music is Yes Yes Y'all by Matt Large. Our cover art was designed by Shirin Raban. If you want to hear more podcasts, check out our website, uc3p.org. And if you want to contact us, our email is theuc3p@gmail.com. Before we go, I'd like to mention that UC3P just published a brand new series, Root of Conflict. It's a show that talks with leading experts about violent conflict around the world. Their first episode is with Professor James Robinson, and they discussed why some countries move toward liberty while others don't. Check out Root of Conflict on Apple Podcasts, Spotify, or wherever you get your podcasts. Again, that's Root of Conflict wherever you get your podcasts. My name is David Raban, and stay tuned. We'll be back next week with our brand new miniseries, Bite Size Policy.
It sounds like there's a lot of work that comes before litigation and... Wait, so I stopped reacting. Okay.
Something about litigation. Things. I'm sorry.
Things and stuff.
Okay.
That's so beautiful.
Thank you. Okay, I think that's our next blooper. So...